All right. The next case for this morning will be Florida Organic Aquaculture versus Advent Environmental Systems.
May it please the court, John Urban on behalf of the appellant, Florida Organic Aquaculture, LLC. And I'd like to just reserve 3 minutes,
Okay.
well, 4 minutes for rebuttal. I'll
All
take
right.
16. Your Honors, this is an appeal of a final judgment and related order awarding attorney's fees pursuant to a demand for judgment. And a quick sort of relevant procedural history.
We're familiar with the facts of the case.
Okay, and then let me go on to the order that originally denied the attorney's fees expressly was hinged on Diamond Aircraft, and it said, based upon inter alia, the holding of Diamond Aircraft Industries and the requirements of Rule 1.442, the plaintiff's motion is denied as to attorney's fees.
Right, so we're not talking costs here, really.
Correct.
The issue here is the attorney's fees.
Yes, Your Honor. The costs were awarded on a different basis. Now, on April 27, 2016, the plaintiff filed its motion for rehearing on its motion to tax costs and attorney's fees, and a motion to stay in light of the pending board and dairy case that was in front of the Supreme Court. And the stay was granted.
And it gets stayed, and the cases get decided.
Yes, Your Honor.
And then they go ahead and they set the motion for rehearing. They set a hearing on their motion for rehearing. You then submit a supplemental memo, and the trial court, without having a hearing, without waiting for their response, I think it was 1 day after your memo, rules and denies the motion for rehearing. Correct?
Yes, Your Honor.
Okay, so as I indicated, we're familiar with the facts, so let's talk the legal issues involved.
Yes, Your Honor. Well, there's two completely separate bases for appeal here. The first one is the jurisdictional issue, that once the court's order denying plaintiff's motion for rehearing was entered, the court had no further jurisdiction. It was done. It was clearly the last
If that was a final order.
Yes, Your Honor. And completely separately, the second basis for appeal is that even if the trial court had retained jurisdiction, which it did not, it erred in granting the plaintiff's motion for fees because the demand for judgment clearly did not comply with Rule 1.442. And I'd like to address each.
And if you prevail on the first issue, we don't get to the second issue, correct?
Yes, Your Honor, because anything done after that would be completely without jurisdiction, without effect, and should be vacated. So on the jurisdictional argument, Your Honors, this very court made it clear in the Ziegler case in 2014 that nomenclature does not control, and motions for rehearing or reconsideration aimed at final judgments shall be treated as Rule 1.530 motions for rehearing. So whether it's reconsideration, rehearing, it doesn't matter. There's only one matter left, and that was the fees determination. Once the court stayed and waited for the Supreme Court, counsel filed that board and dairy case. The court looked at it and said, oh, I'm denying your motion for rehearing because I'm staying with my ruling. The Supreme Court, also directly on point, stated that the test employed by the appellate court to determine finality of an order is whether the order in question constitutes an end to judicial labor in the cause, and nothing further remains to be done by the court to effectuate a termination of the cause as between the parties directly affected, which is directly the case here. The only thing left to decide, costs had already been awarded, none of that's at issue, final judgment had been entered. It was whether or not fees should be awarded. And the court said no, then granted reconsideration, and said no again. And that was the end of it. And we have directly on point case law. Where an order after judgment is dispositive of any question, it becomes a final post-decretal order, and that is the Sampson Supreme Court case, long-standing law. Also in Cantera, Florida Supreme Court, 1990, it stated if a motion for rehearing is denied, it is not subject to reconsideration because the trial court is divested of jurisdiction. Again, directly on point to the facts here. Also, Shelby, a Florida Supreme Court 1970 case, finding that the trial court lost jurisdiction upon entering an order denying plaintiff's petition for rehearing and had no jurisdiction to consider plaintiff's motion for reconsideration. Every Florida appellate court that has considered this has come to that same conclusion. You cannot have yet another bite at the apple. Matter of fact,
Let me
respectfully-
just to clarify, though, no grounds were raised pursuant to 1.540, is that correct?
I'm sorry.
The
in
relief
the
from
trial court?
judgment, decrees, or orders, there were no allegations that raised any 1.540 issues, is that correct?
That is correct. It would be 1.530.
Well, no, 3.0 is the motions for new trial, rehearing, amendments, and judgments. What was being sought was relief from an order, right? They wanted to be relieved from the order of the court that denied the motion for rehearing.
Correct. It could be looked at that way, but again, nomenclature, that's why I quoted this portion, that it doesn't matter what they label it. There was a ruling, the court had the opportunity to reconsider its ruling, and it granted that based on Board and Dairy. Once that case was filed, approximately a week later, the court entered its order saying, okay, that's it. I'm denying the rehearing because I've looked at Board and Dairy and I'm staying with my ruling.
And your position is that the way to challenge that would have been by appeal?
Absolutely, Your Honor, because the court no longer had jurisdiction. And again, every Florida Supreme Court and appellate court ruling holds that as the law. And that was argued below. And counsel, even in their answer brief, quotes that exchange with the court. Respectfully, a pleading titled, "Order Denying Defendant's Motion in Opposition to Entry of an Order and or to Vacate Order Granting Plaintiff's Motion for Reconsideration of Order Denying Plaintiff's Motion for Rehearing," which is at issue here, is an impossibility or is impermissible in Florida courts. It is exactly, the title itself is repugnant to the idea that you can have a chance at rehearing and then the court loses jurisdiction thereafter. And there's no question whatsoever that there was nothing else for the court to labor over. I mean, the only thing left was this fees issue. So it's certainly closed as of that issue, but there was no other issue. So it's not even where the court has to decide, well, were there still open issues? There was nothing else. Accordingly, the trial court should not have entered an order granting plaintiff's motion for reconsideration or any other orders in this matter, and the order granting same and all subsequent orders are void and should be vacated. And as the court pointed out earlier, which means we don't even get to the second issue. But we do have a completely separate basis for this appeal. And that is the deficiency of the offer of judgment. So I'd like to now get into that completely separate issue.
In the event that we disagree with your first issue, go ahead.
Yes, Your Honor, exactly. So if the court does find the court had jurisdiction, then we still have the issue of that Florida statutes 768.79 and Rule 1.442 control attorney's fee awards on a proposal for settlement. And the Florida Supreme Court has repeatedly and unequivocally in all its cases, including the recent Wheaton case, the Diamond Aircraft, Board and Dairy, it states the parties must strictly adhere to the requirements of the statute and the rule to be eligible for an award of attorney's fees and costs pursuant to an offer of judgment. Because the overall subject is in derogation of the common law, all portions must be strictly construed. The district court erred in failing to strictly construe the plain language of the rule and the statute. And that's a direct quote from Diamond Aircraft. And now the rule 1.442 itself, in relevant part, provides Section 2, a proposal shall, and then it enumerates A through G of what shall be in there. and F is what's at issue here, and it states whether the proposal includes attorney's fees and whether attorney's fees are part of the legal claim. And that's really the crux of this whole second appeal basis.
How do you square that with the board and dairy language that says that the court will not invalidate an offer of judgment for failing to strictly comply with something that the statute does not require, rather than the procedural rule?
Because there, the Florida Supreme Court had already decided Diamond Aircraft was deciding board and dairy and did not recede from Diamond Aircraft. It said, in the context of where there's nothing in the pleadings asking for attorney's fees, only then does it say, you know, we're not going to have this technicality destroy the offer of judgment or invalidate it because there's no issue. Unlike the case here, where in their complaint at issue, they said, this is a complaint or this is an action for $15,000 plus and attorney's fees. So they sought attorney's fees, and the court hits the nail right on the head. That is the bright line rule separating Diamond Aircraft, where the pleading at issue has a request for attorney's fees, and board and dairy, where if the pleading is silent on attorney's fees, then are we really going to invalidate a offer of judgment just because it doesn't say, hey, the pleading happens to not ask for attorney's fees? And it's especially on point, Your Honor, here, where counsel itself has said, well, yes, admitted, we did ask for attorney's fees, but we kind of ineptly pled it, and therefore, you know, why don't we just pretend there wasn't really a basis for fees? Well, that actually makes our point. How is our client supposed to just know, well, am I getting the value of attorney's fees exposure also?
The offer specifically stated that the proposal, under the proposal for settlement, that each party was responsible for its own attorney's fees.
Correct. But it does not. And that absolutely, as your court states, that is 2F Part 1, where it states it has to state whether the proposal includes attorney's fees, and it absolutely does. Each party is going to bear their own. But it says and it says a proposal shall state that, and whether attorney's fees are part of the legal claim. They didn't do that. There's no escaping that. They try to excuse it away or explain it away by saying it was inept pleading. Well, that doesn't carry the day. This is in derogation of the common law American rule that everyone bears their own fees. If we're going to have parties burdened with the attorney's fee at the end of the case, they have to strictly comply. And the Florida Supreme Court has relentlessly and unequivocally and repeatedly held to exactly that. Diamond Aircraft is still good law. Afterwards, board and dairy came. They distinguished it from Diamond Aircraft on that basis of the pleading. Then came Wheaton, which, again, the Florida Supreme Court is directly addressing offers of judgment, separate issue about validity of service, but they, at no time, and the Supreme Court certainly knows what its prior rulings were, did it try to go back and somehow say, you know what, we might have gotten a little too hyper-technical. And I'll admit, it is very technical, but it is directly on point. And I think it's rare for this court to have such exactly on-point guidance. Matter of fact, the Diamond Aircraft case expressly states as a certified question, directly on point, is a defendant's offer of judgment valid if, in a case in which the plaintiff demands attorney's fees, the offer purports to satisfy all claims, just like here, as the court pointed out, but fails to specify whether attorney's fees are included, and fails to specify whether attorney's fees are part of the legal claim. Right there, the court says, if it doesn't do that, then due to the strict construction required of Rule 1.442, we answer this certified question in the negative, meaning, no, it is not a valid offer of judgment, unless you specify.
In the case that you're citing, where did the pleadings allege, make a request, demand for attorney's fees?
In the Diamond Aircraft?
Did the underlying pleadings have a request for attorney's fees?
Yes, absolutely, Your Honor. That is the whole distinguishing factor.
The pleadings did, but this offer of judgment went a step further than the offer of judgment in Diamond Aircraft. Instead of Diamond Aircraft had all claims, here this offer of judgment has a separate line for attorney's fees specifically in addition to all claims.
Correct. It says.
So it is somewhat distinguishable.
I would absolutely disagree, Your Honor. The certified question in all capitals that the Supreme Court of Florida addressed in Diamond Aircraft says whether attorney's fees are included, and they absolutely said, hey, attorney's fees are included in this offer of judgment. But then it says, and fails to specify whether attorney's fees are part of the legal claim. Well, they failed to specify. There's no question about it. The only mention of attorney's fees in the offer of judgment at issue is that each party will bear their own attorney's fees. Nowhere does it state, as required, and as the Supreme Court directly addressed in its certified question, that the fees are included in the plea, or anything referencing at all. I mean, I don't even have to explain anything away, because all it says is each party bears their own attorney's fees. And the very sort of argument raised that, well, maybe there wasn't a proper claim for attorney's fees, even though there clearly was. It says in paragraph 1, this is an action for attorney's fees, among other things. So again, that creates that ambiguity to really have.
So your position, just I want to be clear, your position is that their pleadings were not inept, that they were very clear, and that they sought attorney's fees.
100%.
So you could have looked at the time you received this offer, you could have looked at the pleadings and without a doubt determined, you're on your own, without them telling you, that they were indeed seeking attorney's fees in the action.
Well, I mean, not.
Yes or no?
Yeah, absolutely.
And that was clear.
Yes, I could have. We could have read the complaint. There's a second amended complaint and said, okay, this was the dispositive pleading. They're seeking fees. That must be in there. But that's not our burden. Matter of fact, it goes on to state that you cannot. Let me see. There's some wording in one of the Supreme Court decisions that actually says, it addresses that exact issue, and it says, you cannot change the burden. This is in derogation of the common law, strict construction. You want to do an offer of judgment and saddle the other side with that liability, you need to comply, and you cannot shift the burden onto the other party that is receiving the offer of judgment to start trying to interpret things. That's the whole point of the strict construction.
You're within your rebuttal time if you'd like to remain or retain it.
I'd just like to make one more point. And this goes to the court's question about the distinguishment. And this is Bordenberry quoting Diamond Aircraft saying, unlike the complaint in Bennett, which is what Bordenberry was considering, the complaint in Diamond Aircraft contained a legal claim for attorney's fees, which created an ambiguity in Diamond Aircraft's offer of settlement that was not present in Bennett, thereby necessitating the presence in the offer of settlement of a specific statement regarding attorney's fees. So again, Diamond Aircraft absolutely was in the pleading, and certainly there the Supreme Court did not say, well, maybe you should have looked more carefully and made your own determination. So again, we would ask for those two independent bases that the trial court be reversed as to attorney's fees and that it be vacated. Thank you.
Good morning, Your Honors.
Morning.
May it please the court. My name is Amber Davis, and I'm here with my co-counsel Jackson Brownlee. I will be addressing the jurisdictional issue, and he'll be addressing compliance with the statute and rule. As the court's aware, on April 22nd, the trial court denied plaintiff's motion for fees based primarily on Diamond Aircraft.
Why wasn't this a final order?
This ruling was not a final order because it was an order after final judgment. And if you look at 250
It was an order that denied a motion for rehearing, correct?
It was an order that denied a motion for rehearing that
Why isn't an order that denies a motion for rehearing a final order? What other judicial labor was necessary?
Well, so to the first part of your question, it really wasn't a motion for rehearing. It was a motion for reconsideration.
What did you label it?
We labeled it a motion for rehearing.
Oh, so you were wrong when you labeled it a motion?
We were absolutely wrong.
Well, I mean, really, please.
Ron, if you look at the case, if you look at the Siegler case, it specifically says that nomenclature does not control. Motions for rehearing or reconsideration aimed at final judgment shall be treated as a Rule 1.53 motion.
No. The order that denies fees, attorney's fees,
Yes.
doesn't need a final judgment, and that's it. If it grants it, then you're going to have a final judgment. But if it denies attorney's fees, you don't need to then enter a judgment that says anything beyond that. And there's all kinds of case law that supports that proposition.
There's also all kinds of case law in this specific district that it says the exact opposite.
Well,
So-
counsel said, that says what?
That says, for example, Redbird Laundry versus Parks, which is the 50 CA case in 1999, and Mills versus Martinez, which is the 50 CA case from 2005, specifically talks about and says that a denial of a motion for attorney's fees, that is post-judgment, which is what we have right here, is a non-final order. In the case that he's primarily relying on, the BDO case, specifically talks about,
What further judicial labor was necessary?
Your Honor, the judge did not enter a final judgment as to attorney's fees and costs.
Okay, so you think that a trial judge denies fees has to then enter a final judgment that says that?
Yes, and Danford versus City of Rockledge, which is a 50 CA case from 1980, specifically states that orders that neither contain the traditional words of finality nor other words of similar import are not final judgments, subject to appellate review. If we look at Appellant's Appendix Tab 2, nowhere does it say final judgment, nowhere does it say let execution issue. This is not a final order, it's not a final judgment, it's a
How do
non-final
you
order.
distinguish Trueblood, McMahon, Wilson versus Ford, Arleo versus Garcia? How do you distinguish those cases?
Your Honor, every case that he cited to, there was a specific final judgment and then a motion for rehearing, which was denied. Here, there was no final judgment. There was a non-final order. And if you look at Redbird, and I quote, and this is citing a 40 CA case that's in his BDO case, it says, there the court held that the denial of a post-judgment motion for fees, is an appealable non-final order. If we look at Mills versus Martinez, this was after a favorable verdict on a breach of contract action. The court entered an order granting attorney's fees, then sua sponte changed its mind and then denied the motion for attorney's fees, saying that the plaintiff had apparently served the order too early. And the defendant in that case argued that the court didn't have jurisdiction. Here, the 50 CA specifically says an order that merely grants or denies a motion does not resolve the issue conclusively. It has long been established that a trial judge has the right and authority at any time before entering final judgment to change its rulings. And when in opposing counsel's argument, you made mention of Rule 1.540, and I'd like to address that. So if you disagree, but I urge you to read the cases that I've cited to, if you disagree and you hold that this was somehow a final...
Are you suggesting that we haven't read your brief in the cases?
No, I'm not suggesting that at all, but that the Mills case was not in my brief, so...
It's not in your brief and you haven't done supplemental authority, then you can't argue it.
Then I'd ask to allow me to...
You should have done that before oral argument.
I understand that, but if you look at the cases that are cited in our brief, I think you can see that this was a non-final order. So when we filed our motion for rehearing, which was mislabeled, in which Siegler says it doesn't matter what we call it, it matters what it is, and what it was really a motion for reconsideration. And motions for reconsideration can be altered at any time. I mean, Siegler specifically says that the court has the inherent power to reconsider and, if deemed appropriate, to alter or retract any of its non-final rulings prior to entry of final judgment. We had a final judgment as to liability, but we did not have a final judgment as to attorney's fees and costs. And
Now,
it would be a gross miscarriage.
I'm trying to understand why you feel that you need to change the label of your own pleading. If it was, your position is that motions for rehearing on an order denying attorney's fees are non-final, so that wouldn't matter anyway, would it?
No, my position is that there can be no motion for rehearing on a non-final order because Rule 1.530 is only relevant to final orders. And this was a non-final order.
Y'all are the ones that drafted and filed it. And I'm not sure that I, agree with your characterization. I'm still trying to understand, your argument that you have to separately, after you've denied attorney's fees, have to then enter a final judgment, a separate final judgment. I'm not sure that I understand why you would have to do that.
What does it look like, counsel? I mean, what does the court, after the court says, no, you don't get attorney's fees, denied, what does the court do then to make that final?
The court then issues a final judgment
That says-
as to attorney's fees
That
and
says,
costs.
that says what? The
That
same
says-
exact thing? They just cut and paste the same language in and call it a final judgment this time?
It needs to be labeled a final judgment. It needs to say, let execution issue.
Well, what are you
especially
going
with
to,
respect
when you're
to-
denying attorney's fees, what are you going to execute?
Well, Your Honor, the question is whether or not the judicial labor ended.
I know,
And
I'm
it did
not. No, but what I'm asking you is, if the court rendered something that said final judgment, and then it said no attorney's fees, you get 0, for which let execution issue, what are you executing?
But we're not, in this case, there was an order, a non-final order.
Try to answer that question, because
I really-
I'm not understanding it either.
What does that mean when the number is 0? I get it if you're saying, hey, you get $1 million in attorney's fees, for which let execute, I get it, right? But if the number's 0, you get nothing.
The number as to attorney's fees
What are
was
you
0.
executing then?
But the number as to cost was not 0. And that
This
there
isn't
was
about
still
costs.
judicial labor.
We're talking about attorneys.
This is a jurisdictional issue, so let's say for a moment costs aren't at issue. There was no motion for costs, it's just attorney's fees. Because the fact that costs are in there doesn't affect this analysis. What are you executing if the number is 0? The award is 0, what are you executing?
You're not executing anything.
So what does the final judgment say then in that case?
Final judgment will say final judgment as to attorney's fees.
But aren't the
court-
cases legion that say the nomenclature doesn't matter? That doesn't impact, it's not decisive on whether or not something is a final order or final judgment.
Well, Danford versus City of Rockledge specifically says that it needs to have the traditional words of finality, and no other words of similar import are, if you don't have those words of finality, it's not a final judgment. But I want to address.
Because it's not clear from the face of the order that the judicial labor is ended. But here, even under the Fabian case where it was a non-final order denying fees, because the court specifically reserved jurisdiction to revisit the issue essentially after final judgment was entered, it's completely clear from the face of this order denying fees that the judicial labor is done. There's no question about it.
Okay, well, let's argue, if you believe that this was a final order and that the court was divested of jurisdiction when the motion for rehearing, which I contend is really a motion for reconsideration, but a motion for rehearing was denied, then I think the court still had the authority under Rule 1.540A to revisit and
But you
correct
didn't
it.
allege those. That's, I looked over the motion, and I didn't see anything in that motion that alleged the grounds of 1.540.
Right, but the court can do that sua sponte on their own. And what the court did, and if you read the hearing transcript at
But
appendix, appellee's appendix
If the court
page,
didn't have jurisdiction, the court didn't have jurisdiction.
at appellee's appendix, page 66, Judge Chase specifically says that if it's the court's mistake on entering an order without hearing from both of you on what the Borden case ultimately said, then that seems prejudicial to Mr. Brownlee's case. And when you have a mistake that can be corrected sua sponte by the court under Rule 1.540A, and any error, the trial court judge can alter, modify, or vacate an order of judgment if there was an error arising from oversight or omissions.
Counsel, I hear what you're saying, and I appreciate the argument, but I think to get me on that argument, you're going to have to explain this to me. If we interpret 1.540 the way you're suggesting, doesn't that swallow the finality rule? I mean, isn't everything at that point a mistake that well beyond the 30 days, a trial court can say, hey, I made a mistake. 1.540, I'm going to go fix it.
Not everything is a mistake. But
Can you explain that to me then?
She specifically used the word mistake, said that she made a mistake.
So a
And
trial court
counsel-
can sort of revive its jurisdiction and beyond 30 days if it uses the word mistake.
Well, no, I think in this case, it'd be a miscarriage of justice when opposing counsel mischaracterized and potentially misrepresented the Borden case in the supplemental authority.
This isn't about what they did. this is about what the trial court did and about what your remedy was to alleviate that issue. The trial judge, did what she did, ruled in one day, canceled the rehearing, and that is what it is. The question then became, what was your response to it? And your response could have been to file a notice of appeal, but you didn't do that.
Well, but Your Honor, if you look at appellate rule, and I want to leave some time for Mr. Brownlee, but if you look at appellate rule 9 point, I'm sorry, I need to find it, 1.110K, it specifically says that we can wait until the end of the case to appeal, which would have been after, which would have been at this time, and when this appeal started, as opposed to right after that order, or within 30
Well,
days
doesn't
of
that
order.
depend on whether or not, doesn't that sort of beg the question of whether or not this was, the order denying the rehearing ended the judicial labor? I mean,
Yes.
the whole question is when does that, sorry.
When
The
does
whole
it-
question is when does that 30, and look, certainly, whether an order is final or not, that's sometimes a sticky situation, right? We can reasonably disagree on that and everything else, but isn't that when the 30 days, isn't the issue when does that 30-day start to run? And if the appellants are correct on this issue, the 30 days started to run right then. And you needed to file a notice of appeal within 30 days of that order, correct?
If they're correct,
Right.
but what my position is that there needed to be a final judgment
Now,
as to attorney's fees and costs.
listen, we need to
Yes.
let Mr. Brownlee earn his money.
I agree.
So,
Thank you, Your Honor.
all right.
Police Court, my name's Jackson Brownlee, and I just have one comment on that issue. I probably shouldn't say it, but
Oh, no. She argued one, and you're arguing the other part, so so go ahead, let's argue the
Okay.
point of law that you're here to do.
Your Honor, the issue before this court is whether or not we complied with the rule. The Florida statute is in derogation of common law and must be strictly construed. We complied with the statute, exactly down the statute. The issue is whether or not we complied with the rule. The rule is not in derogation of common law because procedure cannot be in derogation of common law unless it is supporting what is in the statute. And this is the issue which the Supreme Court considered for the first time in this case, is whether or not a rule which has a provision which the statute does not must be strictly construed.
And I agree personally that that is what the Borden Dairy case says, but then you look at the Supreme Court's later precedent, for example, in Allen v. Nunez, and they again reiterate that in addition to being unambiguous, the language from that case specifically says you have to comply strictly with the rule and the statute.
But Borden Dairy says that whenever the rule makes a requirement that the statute does not, then we're going to look at whether or not it's ambiguous. And that is, in fact, I had prepared the same quote which he read to you concerning the Diamond Aircraft case, because in Borden, in the Supreme Court, in referring to Diamond Aircraft, talked about that unlike Bennett, Diamond Aircraft contained a legal claim for attorney fees, which created an ambiguity in Diamond Aircraft's offer of settlement that was not present in Bennett, thereby necessitating the presence in the offer of a specific statement regarding attorney fees. We have a specific statement regarding attorney fees in our offer. That specific statement is each party is going to bear its own cost and attorney fees, and I submit to you that any freshman in law school would know what that means. It was not ambiguous whatsoever. They knew it, and they've never argued otherwise. From the time beginning, it's always been, I got you. You didn't cross your T, you didn't dot your I, and therefore you lose. I submit to the court that based on Borden Dairy case, which is new law, and a court said, don't worry about it or not to go there, but there was a representation in their supplemental memorandum, we didn't get the answer, that said that there had been no change in the law. I submit to you that is definitely a change in the law in board and dairy. And so that is new law, and it's new law because I've cited a couple of cases that since then have reversed based on board and dairy. One of them is Aquata versus Miller, 219 Southern 3rd, 216. Same situation where the trial court initially in our case didn't have the benefit of the Supreme Court ruling, and they denied attorney fees. And then the 3rd District sent it back and says, based on Borden, award attorney fees. Also, Taylor Engineering versus Dickerson, 221 Southern 3rd, 710. Again, based on Borden dairy, they reversed a finding by the
Those were
trial
all
court.
cases, those, weren't they, where attorney's fees was not pled? There was no request for attorney's fees in the pleadings.
That may be in those cases, but here, I go back to the argument where the rule makes a requirement that the statute does not. I submit to you that based on Borden dairy, the test of compliance with that rule is now absence of ambiguity, not strict construction. And that's, basically based on that particular case. I think their I got you theory goes out the window. We would respectfully request that you affirm the trial court in this case. Thank you.
All right, thank you, sir. Ms. Davis, if you want to go ahead and file a supplemental authority on that one case, if you could file that, can you get that filed today?
Yeah.
All right, okay.
May it please the court.
Counsel, if the test is lack of ambiguity, you've already conceded there was no ambiguity, correct?
That the pleading stated that it was seeking fees?
You said it was clear that they were seeking attorney's fees, correct?
It was clear that in the pleading...
So there is no ambiguity, at least?
Well, if I can answer completely?
Yes.
There, in paragraph 1, it states, this is an action for $15,000 and attorney's fees and costs. Then they incorporate that into each count in the wherefore, in the incorporation clause. Then in the wherefore clause, and this is interesting, they say, again, we ask for all this relief and attorney's fees, if applicable. So I would say, yes, absolutely, they asked for fees, but look at that. In their own pleading, they then say, if applicable, it creates ambiguity. It's exactly...
Well, wait a minute, just when you stood up here just a few minutes ago, you said there was no ambiguity.
Yes, Your Honor. What I'm saying is, and I'm not trying to talk out of both sides of my
So
mouth.
there is actually, you're saying there is ambiguity.
No, what I'm saying is it clearly asked for attorney's fees. But as far as the offer of judgment, it didn't say whether the pleading asked for it.
No, I know it didn't say that, and they're not claiming that it said that. They're saying, look, they're saying that the test is ambiguity now, and assuming that, let's assume for a moment that that's what we're supposed to look at.
Yes, Your Honor.
You conceded earlier that there was no ambiguity, and I'm just sort of giving you an opportunity to walk me through that in case I misunderstood you somehow.
Absolutely. I believe that they asked for attorney's fees. They believe that was just in there because of inept pleading. So clearly, I believe it was unambiguous. They believe it was ambiguous. This is exactly why Diamond Aircraft requires that if it's in the pleadings, actually, the entire rule for everyone says you have to add it in your offer of judgment. All that Borden Dairy says is, you know what, if you didn't ask anywhere for fees in the pleadings and you didn't put it in the offer of judgment, we're essentially going to, and pardon my slang, but let it slide. We're going to not invalidate an offer of judgment where you never asked for fees and you
Because it's
didn't.
obvious at that point, right? I mean, there's no ambiguity.
That's right, because there's no basis for it. So as the court pointed out, yes, absolutely, we can look at the pleading and
If
figure
it's
it out.
equally obvious, though, that fees are being sought, then why wouldn't the same rule apply?
Because of exactly what I just pointed out, the difference here, and respectfully, in its infinite wisdom, the Florida Supreme Court has directly addressed this in the certified question. And this exact issue is Diamond Aircraft,
Thank
and
you,
it
Counselor.
never backed off of
All right, your
that.
time is up, sir.
Thank you.